Hi, I'm attorney Gregory Dell, and I'm joined by attorney Alexander Palomara, and we're going to talk about one of Alex's resolved cases against the Standard Disability Insurance Company. And this was a great victory on behalf of the client against the Standard. And in this video, what we like to do is talk about the background of the case, what you had to do, the strategies you put in place, and then provide some tips that will help people not only with their appeal, but also if they're on claim and they're worried about being denied, strategies that they can take. So give us the background of this case against Standard.
So my client had previously worked for Hitachi. He was a software engineer, worked there for a few years. Unfortunately, he came down with back issues, shoulder issues, as well as neuropathy, a lot of pain. And as well, he kind of had an issue with cognitive dysfunction. The doctors didn't know what was going on. There was a suspicion of pre-senile dementia, but no diagnosis at that time. He has to stop working, too much pain. He finally stopped working in 2017, filed a claim for short-term disability benefits. Even before he contacted us, his claim was approved. He thought he was going to be fine, going to get short-term disability, going to long-term disability because there was no way he was getting better. After 2 months of short-term disability benefits, his claim was denied, unfortunately. That's when he came to us, and I spoke with him, got a copy of the denial letter, got a copy of the claim file, and I started representing him.
And what did you learn was the basis of their denial? What did they rely upon?
They rely upon what's known as an independent consultant's review. So basically, they go out and they either hire a third-party physician or they hire a company to hire a third-party physician to do a medical records review. So they're not actually speaking with the client, they're not actually speaking with the patient, they're actually just performing a review of the medical records. And of these medical records, the doctor, typically what they do is they point out, reasons why this person is not disabled, or reasons why this person can actually do their job. What's funny about this case is I get the consultant's report. I find it in the claim file. That's the one of the main things I'm looking for in the claim file is the consultant's report. I find it, and the consultant's report is not damning at all. It basically said that my client, has these diagnoses, didn't fight the diagnosis, but the doctor said we could use more medical records, more office visit notes, and maybe the raw data of the neuropsychological evaluation. So the insurance company didn't go back to the client and say, our client, and say, please send us more records or the raw data of the neuropsychological evaluation. They just said, we're denying your claim. So I got this denial letter, I see this consultant's report, and I said, this is a pretty easy appeal. This is kind of crazy what they did here. Beyond that, I even spoke to my client's treating providers, and I got even more support from all of his treating providers. They were supportive before him, even more supportive now after I got him to fill out more attending physician statements and letters of support. So I got updated objective evidence, more support from the doctors, and I can point out to the insurance company where they went wrong. So we filed this appeal. Appeal was successful. We get the rest of the short-term disability claim approved. By this time, long-term disability is ripe for being approved as well because the client's been out for way longer than 6 months. And the Standard does the right thing. They approve the long-term disability claim. And at this point, even though he's been out for such a long period of time, and his policy has what's known as a change in definition of disability, that after 2 years of long-term disability benefits, what it means to be disabled changes. For the first 2 years, it's own occupation. After 2 years, it's any occupation for which you're qualified based on your training, education, and experience. Even though the case is actually ripe for any occupation, for some reason, the Standard did not perform a review for any occupation. So they said, we're approving short-term, and we'll approve the first 2 years of long-term, and we're going to go back and perform a review for any occupation now.
Okay. And so you won basically 24 months of benefits plus the short-term, and you continued to represent him on his claim, and and then into this period, and then Standard basically says, oh, by the way, we did a review again, and even though we thought he was disabled before, now we think he's not disabled.
Correct, which is kind of what happened. So they actually, when they're doing this review from ENEOC to ONOC, we're just sitting here waiting and keep on providing more information to them. And ultimately they say, we don't find him disabled from any occupation.
So what did they rely upon now? This is the second time you're representing him with a denial. And what did they rely upon the second time?
So the crazy part is I get this denial letter, all right? And the claim's a bigger claim. The guy made a lot of money. And this denial letter was 2 pages, all right? And I was suspect. I go, what have you been doing for 90 days? You send me a denial letter that's 2 pages long. The denial letter only talks about a vocational analysis that they did. Typically a denial letter is going to talk about, they're going to talk about the reviews they had conducted, or maybe it was an independent medical examination, maybe an updated consultant's report. This denial letter we did a vocational review, and we find these jobs that you can do. So I go, something's fishy here. It smells bad. What were they doing for those 90 days? So I get a copy of the updated claim file. I go through the claim file, and it's like literally shocking. It's literally nothing's in there other than the past stuff that was in the previous claim file for the short-term disability claim, and no new reviews. I can find no consultant report, nothing like that. So I go back, and basically I realized that the vocational analysis was relying upon the consultant's report that was used to justify the short-term disability denial that happened actually at this point. This review that they're relying upon happened 2 years prior.
Even more.
Right. So it's just crazy to me.
Right.
So I do another appeal, and my appeal is even stronger than the first one because now I have the fact that the standard has done nothing in 2 years. They've done nothing. The vocational report that they're relying upon, the vocational analysis they're relying upon, is relying upon a really stale consultant's report that wasn't even hurtful to my client's claim. I have more updated information from the treating providers and updated medical records, and we have the results of a new neuropsychological evaluation where the results of that evaluation are not good for my client personally, but good for this claim in the sense that it shows that he has severe cognitive issues. It's pretty much diagnosed as pre-senile dementia now, and unfortunately he's going to go downhill from here, hopefully slow, but I don't see my client ever regaining the cognitive or even physical ability to perform his job or any job whatsoever.
But it's incredible to think that Standard just did this 2-page denial letter, and that how could a human being at this insurance company say, yeah, we're denying your claim at this point after we paid you for 24 months plus the short term, which was probably 90 days or 100 days. So really we paid you for almost 2.5 years. And now we're denying you based upon a report we did 2.5 years ago. Like, did someone drop the ball, or is this the way Standard operates on their files?
I view them suspiciously at times, but this is like one of the worst drop balls I've seen in a long time. And that's why it's important that if you get a denial, you need to know what you're doing. You need to get a copy of that claim file, because my client would have not have known to go through the claim file and see that they're not relying upon essentially anything to deny this claim, and maybe would have done an appeal just putting updated medical information. But you need to point out that sometimes you have to embarrass them in the appeals, because ultimately if they deny the appeal, your appeal is going to get in front of the judge, and the judge is going to see the arguments that you've made throughout the entire process and why they've done such a terrible job with this claim.
Yeah, and it's incredible too, though, the magnitude of this, because this was a client, former software engineer, who was making over $135,000, $140,000 a year, getting about $7,000 a month from Standard, and they just say, sorry, we're not going to pay you anymore. Yep. And so it's like you leave the people high and dry with no income, and they have no evidence. I don't know how, I can't get the human being at Standard who just signs off that letter and says, sorry, I'm cutting. It's like shutting the power off at their house and having no care or consideration whatsoever.
That person's either overworked or underqualified to perform this job. I've dealt with people at the Standard in the past and do so on a daily basis, and there's qualified people over there. They might make decisions that I disagree with, but I can see justification on their end sometimes, But this situation was just, I don't know what happened. I feel bad for my client because he had to go a long period of time without benefits. That's the worst part. He went months and months at a time with no benefits. Luckily, he's finally receiving benefits again. We just received this approval letter 2 days ago, and he's going to be receiving benefits until his policy expires at his Social Security normal retirement age. But he had to go months without benefits because the person at the Standard they didn't do their job. I don't know what they were doing, but it was not their job.
Well, it's was there anything you think the claimant could have done differently in order to avoid the denial?
Not in this scenario, unfortunately, because the Standard was going to do, what they were going to do is essentially nothing, Right. But sometimes it is best just to keep the insurance company well fed with as much support as you possibly can, because if you keep on feeding them proof, it makes it more difficult for them to deny their claim.
The only saving grace here is that we were doing that because we were representing this claimant, which means, there's no guarantees that we're going to keep someone on claim. But when they did finally drop, this denial letter, we were able to show them that they were ridiculous because we had a trend of providing them with all the information. And then when we did the appeal, we were ready to go right away. You were able to do this one really quickly. You didn't have to wait the 180 days because you're like, you got to be kidding me. I've been sending you information for the past 2 years. Nothing changed here. And I think that the appeal decision came back relatively quickly because when you finally got to someone else who had more authority at the company, they realized to say, yeah, this shouldn't have been denied and you're right, and that's why you won. But if this client didn't have you all along, this could have been a process that went on for many months longer and maybe never even got reversed again.
Of course.
So if you're a person with a standard long-term disability insurance policy and you're having any issues whatsoever with your claim, feel free to reach out to Alex, myself, any of our disability lawyers. No matter where you live in the country, we can help you, and we look forward to the opportunity to discuss your claim with you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.